Good evening and welcome. I am delighted to see so many at this Inns of Court Alliance for Women event at Gray's Inn. Joining us this evening or in person or indeed via live stream are practitioners from many areas of the United Kingdom and indeed legal professionals working in India, the Bahamas and South Africa. It was just over a year ago that the Inns of Court Alliance for Women was launched. We built and are building on the work done by the Temple Women's Forum. It can fairly be said that since then the Alliance has gone from strength to strength, not least in building and strengthening our links with friends and colleagues in Northern Ireland and Scotland. Central to the work of the Alliance is the need to be alert to and to respond to issues regarding women in the law. One that is current and concerning is that of judicial bullying. We do not suggest that that concern is confined to women. We are particularly grateful to the Lord Chief Justice for agreeing to speak this evening and to the distinguished members of our panel, which is moderated by Amanda Pinto, King's Counsel, a former chair of the Bar. The panel comprises the Right Honourable Lady Justice Simler, Chair of the Diversity Committee of the Judges' Council, Natasha Wong, KC, and Laurie Powell, KC, both of whom have extensive experience of appearing before different courts. Natasha's chambers are at 5 KBW and Laurie-Anne's are at 25 Bedford Row. Sam Mercer, Head of Policy, Equality and Diversity and CSR of the General Counsel of the Bar, is our fourth member. As you are aware, questions for the panel have been requested and have been received in advance. And finally, can I thank Sam Hutchinson, the Chief of Staff at Gray's Inn, and all the members of the administrative team of the Inns of Court Alliance for Women for the simply first-rate work which they have done in organising this event. That is all I wish to say. May I welcome the Lord Chief Justice.
Well now, good evening everybody, and it's really good to be here. And of course I was at your launch last year, which was just over there as far as I remember. And this is an organisation that I think is extremely valuable, and I've been pleased to be able to give it such little support as I'm able to. Now, the topic of your discussion this evening, I see from the flyer, which I have in front of me, is tackling judicial bullying. And you have a panel of distinguished guests, panelists, Silks and Sam, if I can put it that way, who I know are going to answer a lot of questions and have quite a deep discussion in due course. My task is really just to set the scene, and I should say that unfortunately, once I've finished setting the scene, I'm going to have to leave you fairly well immediately. So I apologise for that in advance. Now, the word bullying is a word which has become particularly loaded, and it defies even most lawyers to give it a definition which is satisfactory to everybody. And I think it is possible to get hung up on a single word, particularly a word that has attracted such loaded connotations. And when I think of this subject generally, I prefer to think of judges behaving inappropriately towards advocates. That's what we're concerned with principally this evening, but more generally about inappropriate behaviour, which can be towards witnesses, to litigants in person, and towards each other. And so I'm not going to focus on the word bullying, because I suspect if we had a debate about precisely what it meant, we would be here forever. Now, judges are human. That's where I start in thinking about this topic and all topics. And since I became Chief Justice, now approaching 6 years ago, the topic of inappropriate behaviour by judges is one that I have taken a great deal of interest in and sought to put in place mechanisms to improve behaviour where it is not at its best. One of the issues that absolutely bedevils discussion about this topic is that nobody is able to provide any quantitative data about how widespread might be the problems, nor the various types of behaviour that are causing concern to members of the bar, and in the context of this evening, particularly female members of the bar. That there are problems has never been denied, at least by me or by the senior judiciary. But we still struggle to determine how widespread they are. So let's put it in context. There are something approaching 2,000 salaried judges in the courts and tribunals in which you all appear, and there are many more thousands of fee-paid judges. And in the course of any day, there are literally 1,000 upon 1,000 of hearings involving not only counsel, but solicitors, legal executives, litigants in person. And I would love to know how widespread the problem of inappropriate behaviour really is. Now, I was reflecting before coming up here this evening on my first gentle foray into this topic, or the first I could remember anyway, which was in the Treasurer's lecture in Middle Temple in February 2019, so that's just over 4 years ago. And I was talking about a changing judiciary in a modern age. And much of the talk was about diversity and matters of that sort. But at the time, for those of you who can remember back to February 2019, there was quite a lot of discussion in the media in particular about sexism faced by women at the bar from the bar. And that was the context of some of the observations I made. And I think Amanda may well particularly remember that time. And at the same time, there was a good deal of discussion about culture at the bar and whether in some areas of practice at the bar, the culture was putting off women from practicing in those areas. And Geoffrey Voss, active in this field too, then Chancellor of the High Court, had spoken to the Chancery Bar Association about what he saw to be the aggression, frankly, in high-value commercial and chancery litigation, and he wondered whether that was putting people off from practicing in the field. And I had picked up in February 2019 some bits and pieces in the press about the criminal bar and women being concerned that they were being treated inappropriately by their colleagues. And I continued, and I'll just read this. A handful of unnamed judges have been criticised. Every word spoken in court is digitally recorded. This alleged behaviour should be called out, and then it will be dealt with either by the leadership judges or within the formal complaints procedure. Judges must behave with courtesy and respect for all who appear in our courts and tribunals, and there will be little tolerance of those few who do not. Now, I was teased then, I remember, by one or two colleagues for using the phrase called out, which they thought was faintly undignified for the Lord Chief Justice. But I used it because it was very much the language that was being used in other areas, and I meant it. So that's 4 years ago and more, 4 years and a month ago. And part of the problem that we have faced since is that this behavior is very rarely called out. Now, the judicial discipline system is, I suppose, at the apex of how you might call it out. And I recognize entirely that very few people, save in an egregious case, would think it appropriate to make a formal complaint to the Judicial Conduct and Investigation Office. But there are almost no such complaints. I can only think of one in recent time that has been successful. I won't name it, although they're all published, as you know. That was one, a judge behaving inappropriately to lawyers in the court. So there's a problem, it seems to me, if bad behavior isn't drawn to the attention of those who are capable of doing something about it. Now, as I say, I fully understand that a formal complaint is the nuclear option, and it doesn't matter what the nature of the complaint. Relatively few people like to deal with it in that way. But there are many other ways in which inappropriate behavior can be dealt with. Now, can I draw a distinction in my own mind, and maybe in some of your minds, between the one-off bit of intemperate behavior, which we've all seen, I saw it as a barrister, which comes from somebody having had a bad day, a really stressful day, and so on, which perhaps many people would say, fair enough, that happens, I shrug my shoulders and move on. But if there are serial offenders, then one way or another we need to know about that. Now, my own view is that if a judge anywhere in the country is a serial offender, then it will be well known amongst those who practice in the court concerned or in the area concerned or whatever the case may be. Just looking back to when I was a head of chambers, now rather a long time ago, although it's very good to see one or two old colleagues here and one or two who I had the benefit of leading, perhaps in truth being led by. I would often hear from members of chambers about what might be called inappropriate behavior from judges. And there were, and I see my former senior clerk is here, so he'll know exactly who I'm likely to be not talking about, but having in mind. And there were one or two who were serial offenders. And what could be done was to draw the problem generally to the attention of the relevant leadership judge or presiding judge and say, look, you need to know that Judge X sitting in County Court Y is routinely being offensive to lawyers and witnesses, and then something might be done. And what actually depresses me a little bit about a gathering like this tonight is that everybody who's here, and I gather we're being live streamed, so there will be quite a few others who are joining us remotely, are here because you know there's a problem. It may be relatively small in the context of the enormous size of the judiciary, but I guess you know there's a problem. And yet, very rarely, even informally, are these problems brought to the attention of the local leadership judges, or maybe if it's the local leadership judges who are the problem, I'm not suggesting that's the case, to the presiding judges and so on. And I really would urge anyone who encounters behaviour that really does cross the line, and you know it when you see it. You don't, leave aside your lawyerly heads looking for an endless definition. We all know it when we see it. Then do something about it. And if you're a relatively junior practitioner and you're worried for reasons that, of course, one understands, then use somebody more senior to make the point for you and draw the difficulties to someone's attention. And I have heard occasionally from people who inevitably I talk to, without naming judges, sort of anecdotally saying, oh, well, I was in a trial and the judge was awful and we all knew the judge was awful. And recently I said to somebody, well, why didn't you do anything about it? And the answer was simply, well, once the trial was over, we all moved on. Well, now, again, I understand that. But if you want me and other leadership judges to be able to take steps to deal with these problems one way or another, we have to know about them. Now, we are taking steps independently of knowing about individual cases. Many of you here will know the sort of work we've been doing generally to improve welfare offering to judges, training to judges in how to deal with people, and particularly in how to avoid behaving inappropriately. And now, nearly 2 years ago, I'm looking to Ingrid for assistance with dates. I was very struck by the work that had been done in Parliament, and particularly in the House of Lords, of which I was aware. Now, of course, any such work is never perfect and often attracts all sorts of snipey comments. But what I thought would be useful for the judiciary was to talk to some of the experts who had been helping in Parliament and see what we could do for the judiciary. And that's exactly what we did. And they organised for us what I suppose amount to focus groups, don't they, Ingrid? Which included not only judges, but also solicitors, members of Silex and barristers, and the professions, the Bar Council, the Law Society, and so on, were very helpful in providing these focus groups. And what they were designed to do was to tease out people's experiences, not to give any quantitative information, but just to give us some for instances about what people had experienced. And the work, unsurprisingly, threw up that there were instances of behaviour which certainly, if accurately reported, I would consider cross the line. So what do we do about it? And particularly, if I may say so, with Ingrid's help, who has been working tirelessly on the inclusivity side of diversity and inclusivity, which this is in truth part of. We have commissioned training for judges to make them aware of the sort of behaviour that can cause offence, for example. Sometimes it's unthinking. Perhaps more often than not it's unthinking. And we've rolled out training for all our leadership judges, including us, but this is for all the DFJs, DCJs, our resident judges and the equivalents in the tribunal, to impress upon everybody how important it is that all judges understand that they must behave appropriately at all times. Now, judges work under a lot of pressure and stress, and occasionally there will be lapses. But we've started with the leadership judges so that they can then inculcate good practice and behaviour into the courts for which they're responsible, and we will be rolling out that training for all the salaried judiciary. Now that, you can imagine, is an enormous undertaking, It's also an extremely costly undertaking, but it demonstrates my commitment and the commitment of the senior judiciary to tackle these issues where they really exist. And as part of it, we published earlier this year something called a Statement of Expected Behaviour. Now, I don't know, I'm not going to ask for a show of hands, but a few warm nods, perhaps, from those who are aware that we did that. So obviously the judges who are here would, I hope, be aware, and even if they weren't, they would probably nod. But it's a public document, and it's something that I would commend to all of you. But I won't read it all out. It's very short. That was one thing about which we had a serious debate. We knew it had to be short. Lawyers are very good at producing long documents, which then are totally indigestible and nobody takes any notice of. So we made it very short. And amongst the things it said is that we should all treat others fairly and respectfully, be mindful of the authority we have, and careful not to abuse it. Now that's a really important issue, because I think as judges we forget sometimes how intimidating we can be. So that, I think, is a very important one. Be aware of how our words and behaviour can affect others. Remain patient and tolerant. Well, we all try, and occasionally, perhaps, if we were honest with ourselves, we would accept that we haven't quite met that high standard. Act professionally and courteously, including under pressure, and avoid shouting or snapping. Aim to ensure that no one in a hearing is exposed to any display of bias or prejudice, and then there are one or two which really are concerned with relationships between judges. But it goes on. If you see or experience bullying, harassment or discrimination or other behaviour that falls short of these expectations, you may raise it informally with the individual concerned if you feel comfortable, or alternatively through all the other mechanisms that I've already identified. Now, there would be those that say, well, a statement of behaviour doesn't matter at all. But we think it does. We think it makes a powerful statement to the judiciary, but also to the world, that this is an issue that we take with the utmost seriousness. Now, the problems are not going to be solved overnight, and the reality is that in this sort of arena, one is always concerned to be reducing, to be mitigating the problems, because perhaps in no organisation are they ever completely extinguished. I'll finish with one observation, if I may. This is born of years of experience, not only in the job I hold now, but particularly was when I was a presiding judge. Occasionally, a judge who has been behaving impeccably and is praised to the skies suddenly is behaving less well. Most of you may well have seen that or know about that. And one thing that I learned, particularly as a presiding judge, is that there is almost always an underlying story, a backstory to that. And one finds that if somebody is being impatient in court and occasionally doing things which are not appropriate, that so often there's a bit of a health issue, or there's a family problem, or something of that sort. And we have set in place enhanced and elaborate welfare systems for judges, which are, and if the judges here would be good enough to nod, I'd be grateful, which are completely different from what most of us had available to us when we assumed our various offices. And so again, that's an area in which we are trying to make a difference. Now, I think that's quite enough from me. I wasn't sure, Nicola, how long you wanted me to talk for, but I think it's going to be much more valuable for you to hear your panelists answer your questions. So thank you very much. Okay.
As I know the Lord Chief is leaving, I'm just going to thank you very much indeed for coming. And I was going to say this at the end, but I'll say it now. I think the fact that you've come and participated shows how seriously these issues are being taken, and that is a really good positive to take away, as well as the other positives that we're hoping to be able to take away by the end. So thank you very much.
Well, Amanda, thank you very much for that.
When I told colleagues that I was chairing this panel, which, by the way, I'm chairing it because I wasn't at the meeting where it was decided who would chair the panel, many were keen to share their stories and perspectives, and I know that that is equally true of our panellists who've already been introduced, and we've got a lot to say, so I'm not going to introduce them again. And a retired judge actually lent me a book called A Short Book of Bad Judges, which was published in 2013. It had a chapter called A Very Bad 20th Century Chief Justice, A Very Bad 20th Century High Court Judge, and 2 more bad circuit judges, just as examples. It explored, but with humour, exactly the sort of conduct that we are going to be talking about this evening. Because a judge who bullies is a bad judge at that time. One who has forgotten their oath of impartiality and their oath to do right by all manner of people without fear or favour, affection or ill will. And although harassment on the grounds of specific protected characteristics is recognised in the Equality Act 2010, bullying is not defined in employment law, making it much more difficult to define, especially as it's often a slow process of undermining or belittling behaviour which may go unnoticed by others. Just before I turn to my panel, may I say this, that ACAS defines bullying as offensive, intimidating, malicious or insulting behaviour, an abuse or misuse of power through means intended to undermine, humiliate, denigrate or injure the recipient. And as anyone who's done criminal law knows, an intention can be the obvious consequence of your conduct. It doesn't mean you necessarily desire the outcome. So our aim in this session is, of course, to acknowledge what is going on, but really to try to concentrate on providing a route to positive improvement, rather than just dwelling on negative conduct, which we acknowledge certainly exists and must be addressed. We're really grateful to all those who have taken the time to ask questions in advance. I have tried to incorporate them broadly into our discussions and the framing of our conversation, because as you can imagine, there were many questions that were variations on a theme. And so without further ado, I'm going to go straight into despite what the Lord Chief says about it not having a definition, what our panellists think the kind of behaviour that we're talking about covers. And just to give you a bit of a route map through, we're going to talk about why it matters. Why is judicial bullying particularly problematic? These are not only all the topics, but it's a bit of a route map. How are we going to improve? How has it already improved, and how are we going to improve it even more? And I think that hopefully by the end of that, we will have covered at least some of the conversations that we have been having over the last few weeks with some regularity. So let me start with you, Natasha. What would you say we're talking about here?
I would say it's not simply inappropriate behaviour, which is a sort of bland, if I may say so, way of describing really not very much at all. I think from what I've heard from colleagues and from my own experience, bullying on the bench is really born out of an imbalance of power and a desire to embarrass, humiliate, make the advocate lose confidence, perhaps make his client or her client lose confidence. It's behaviour that belittles and that has the effect of the advocate in question often feeling they're not good enough for the job anymore, and feeling that they don't want to do the job anymore, and feeling that they don't want to go back before that judge again to do that job. So I think it does encompass, I mean, I could go on for quite a long time, but I'm not allowed to. But I think it encompasses a huge range of behaviour, but the bullying is the behaviour that has that effect of just making the advocate despair, not wanting to do the job.
Laurie-Anne, what about you?
Yeah, I mean, I'd agree with Natasha, but it's important to say that most people go back to, well, it's all recorded, so if a judge is inappropriate, then we just listen to the recording and there you go, we complain. But bullying, especially judicial bullying, is far more insidious than that. Often it's the atmosphere that's created in court by the huffing, the eye-rolling, the sighing, oh, it's you again, okay, dismissing, interrupting. Things that, when you listen to the tape, don't actually seem to be all that problematic. But when you're in a culture, in an environment where you are unable to properly represent your client because of the culture and the atmosphere in that courtroom caused by that judge's conduct, that is inappropriate behaviour that's incapable of being demonstrated by playing and listening to a tape, but one that the advocate experiences and feels nonetheless. And it has a crippling impact on the advocate, because as women, we walk into the courtroom with the burden of discrimination as a result of being in this job in the first place. And so we don't simply bounce into court and a judge is having a bad day and decides to pick on us, and we bounce back out and say, okay, that judge must be experiencing, some issues at home. When we walk into the courtroom, that behaviour has a detrimental impact, not just on the advocate, but it's undermining of the entire system of justice. That's why it's important that we don't just marginalise this to what's said, but to what is done and how it's done.
Well, Ingrid, what would you like to say in relation to the definition of what this kind of behaviour encompasses, as you've experienced it from the other end, trying to sort it out?
Well, I think the ACAS definition is a pretty good definition. I do think it's about the abuse or misuse of power, as Natasha said. And I do think context is critical, as Laurie-Anne said. So expressions of irritation, frustration, being firm, being critical of a barrister's conduct, all of those things may be entirely legitimate and entirely acceptable, but they may cross the line. They may cross the line because, as Laurie-Anne says, of the way the judge is looking or rolling his or her eyes, or other things that the judge is doing. So I do think we've got to recognise that the context, and I do want to talk about this later, is critical, and I'll come back to it if I may.
Thank you. Well, we've already touched a bit on why it matters. From my perspective, I think there are a few things that the reasons I think it matters. I think, first of all, it's not in the interest of justice. If you haven't got a fair hearing, your client hasn't got a fair hearing, or you aren't able to do your best as their advocate, that's obviously not in the interest of justice. But I think it goes a bit further than that, because I think there's also, it has an impact on confidence in the justice system. I think anybody in court looking at behaviour which goes by on the nod because it's not being addressed, and the Lord Chief is right, very often we do let it go by on the nod and it isn't addressed, for reasons we can come on to. But it will undermine confidence in the justice system if somebody is there in court or remotely on a link seeing behaviour which really nobody should be able to should have to put up with at the workspace, least of all in a court of justice, is going on. And then obviously we come on to attracting and retaining diversity in the professions, and also, I may say, in the judiciary, because if you're losing great candidates in the professions, they're not going to be feeding through into the judiciary because they'll already have gone. And that seems to me to be one of the most important ways through. Tell us a bit about advocate health and retention as another reason why these things matter, Sam.
Well, I think that's a whole science out there, and it's the sort of the physical reaction that you can have when you're bullied has real health impacts, headaches, migraines, stress, all the symptoms of stress, and it creates a kind of hypersensitivity, which means when you go back into a similar situation, you're physically not in a good place. You're not able to be healthy and rational in the way that you would be otherwise. So I think, when you actually look at the science and the evidence, this isn't imagined. This has a real world impact on your physical health. And I think some of the points that you were raising before about the impact that it has on people. I sit on the end of the helpline at the Bar Council, and I'm reading the Talk to Spot reports. And one of the questions that we ask at the end is, how has this made you feel? And the sort of comments I get are embarrassed, ashamed, like I don't belong, angry, like I want to leave the bar. And these are the reasons why we've got to deal with this as an issue.
I think one of the problems that we need to address, actually, is this idea that because it's only a few people, we've got to keep it in perspective. And the reason why I say that is because if you're on the receiving end in a particular court and then you go to another court, you don't know how that judge is going to behave towards you because you've already had a bad experience with a judge that you may not know. And so you're all automatically worrying that you might be treated badly again. And I think that's why it's a bit more of a problem than just individual judges behaving badly. I think it actually does have an impact a bit more widely.
Can I just chip in?
Of course.
At that point, because I think it's not just an individual judge in a court centre, for instance, because it becomes a culture within that court centre potentially. And we all know, because we've all been there, we've all been to certain courts where there is a very unpleasant atmosphere and culture that sort of, you almost feel that there's a hostility towards you, not just personally, but almost every advocate that's setting foot into the courtroom. And so I think it's not just a case of putting a few people on a training course. I think it's a case of actually putting everybody through a whole different way of thinking.
From just looking at it from the recipient's perspective, context again is everything, I think, as Ingrid said, and we know that women of colour, in particular black women from working class backgrounds, are more often than their white colleagues, white female colleagues, because after all this is about women, are often experience discrimination at a far greater rate and a far greater level. And so the experience for women of colour, and as I say in particular black women, is that while it might be a one-off for a white middle-class female advocate, for a black woman from a working class background who's already had to defy the odds to get their foot in the door in the first place, so this carries on from pupillage through to tenancy, through to applications, through to the judge. When you enter that arena, it's not a one-off. It's part of your existence as a member of this profession that's from a marginalised background. And so while on the outside looking in, it might be a few bad eggs, from that perspective, the perspective of the person of colour, the woman of colour, working class woman, or women with any other protected characteristics, that is their daily existence in some form or another. The courtroom is just one aspect of that bullying, that inappropriate behaviour. It pervades through every aspect of this profession. And we know that because we do have the data to that effect. So I agree on the one hand, there are far fewer judges who behave in that way than there are of the greater masses. The experiences of those women in this profession who we say we want to reflect the communities and society that we serve are being let down by those few bad eggs.
And I think if I can just add to that, I mean, in the years that I've been at Bar Council, the quality of the data that we now have available to us through barristers' working lives, through the reports that we get, mean that we do have the capacity to cut it, and we can look at where it happens, who it happens to, and what Laurie-Anne has said is black women in particular are so much more likely to experience these behaviours than others, and it can't be denied when we've got the data in front of us.
So we've probably touched on this already, but the question, why is judicial bullying particularly problematic? What's the particular issue for those appearing before judges of calling out or tackling bullying? And obviously the thing we've talked about mainly is the imbalance of power. And I think you've touched on sort of inequality of status in the courtroom, but can you develop that a little bit?
Yeah, you know, when you walk into the court arena as a woman in particular, again, I'm looking at this from an intersectional perspective. The power imbalance is more geared against you if you're a black defendant, if you're a black witness, if you're a black advocate. And that's the reality of the data. This is not just from anecdotal stories. This is what the data and the research tells us. And so, coin the question, well, you should call it out. Well, quite frankly, we're pretty exhausted. And so, it's now a me problem. You know, it was a me problem when I was half as likely to get pupillage because I was black and presented with the same grades. It was a me problem when I was half as likely to get tenancy because I was black and presented with this. Now it's a me problem for calling out the judiciary. Again, and I make it clear that my experiences have been almost always positive. But on the occasions that I've had direct experience of sexism, racism and misogyny, it has undermined all of those positive experiences because it, quite frankly, goes to your core and it's debilitating and crippling. And like I think Sam says, it makes you want to walk away. I know I've got 2 minutes. Sorry, I said to you, I'm incapable.
I'm going to stop you.
I'm incapable.
Right, Natasha, I want to talk to you, Natasha, about worrying and compromising your case, because that's a really big problem, isn't it?
Well, I think the occasions that I can think of that I've been the subject of what I would describe as bullying behaviour in the past, particularly when I was really junior, I would often look at my opponent who was more senior and wonder why they didn't say something. Why did they not? How could they allow me to be treated like this? How could they watch it happen? How could they not want to say something as a human being apart from as an advocate? And I think, you know, we keep talking about the imbalance of power. They're obviously the opposing advocate in the same courtroom, in the same case. They've got a case to run, and, you know, they're sensing perhaps a slight advantage, and I hate to say it, but there is a bit of that, definitely. And also, they're also thinking, well, the judge still has the ultimate power. He's shown where his colours are. He's not on her side. Well, I'm going to sort of exploit this, not in an overt way, but in a sort of make the most of it way. And I think it's a real problem that, I think the biggest problem is people not standing up and saying, was it really necessary to speak in this way? Is that necessary? However it's dealt with, it should be called out. It just shouldn't be allowed to happen.
But I think one of the really big problems is in calling it out yourself is that you're very, very worried about undermining your client's case in front of the tribunal. You don't want to make the tribunal find or be alienated from your case because for some reason the judge has done something which they shouldn't have done. And I use the word they because it isn't limited to men,
No.
we know.
Well, I mean, in fact, to be fair, we should say a lot of the reports that we've had have been, in fact, from young male barristers and very junior tenants, and in fact, of all ages. Somebody of 30 years called phoned me this morning to tell me about an incident involving a female circuit judge who behaved appallingly to him. So we shouldn't be under the illusion that it's male judges to females or white male judges to any particular characteristic of women. It is actually much more widespread than that, and it does affect young men and men of all call, and it is women who perpetrate the same kind of behaviour, I'm afraid to say.
Sam, can I ask you about the problem of the perception or perhaps the reality of lack of action in response to reporting? We're going to talk about how to report in a bit, but just in relation to that, what's the impact of that?
I think people don't think it's worth making a complaint because they don't know what happens. And, one of the things that I'm very conscious of in talking about Talk to Spot, and we have an anonymous reporting platform, and I'm very conscious that I don't tell the bar enough what we're doing with the reports, the types of reports that we're getting, the advice that we're giving out, and that's an action that I need to take away myself. But I'm also very conscious that it's quite hard to understand how many reports are made, for example, to JCIO that don't ever go anywhere. We have the same conversations with the Bar Standards Board when it's around complaints with respect to barristers. It's really kind of understanding, how many reports, what action is taken. If there are informal reports where circuit leaders or heads of chambers have had informal conversations, trying to capture that and trying to get an idea that actually it really is worth making a complaint because action does happen as a result. I think that's an area that we all need to take away and work on.
Can I just make a point?
Yes, please do.
So first, the JCIO publishes its data, so the data is there in terms of what happens. I'm not suggesting the formal avenue is appropriate in every case. It's probably not appropriate in many cases, but the data is absolutely there. But the other thing I wanted to say is something about Spot, Talk to Spot, which Sam has mentioned, and she's going to talk about a little bit more. Last year, Sam and I met at my request, and Sam gave me some themes. Obviously, they're confidential reports by barristers about experiences they've had in court. But she gave me some themes of things that were happening. And I was able to use that, and I did use it, in my discussions with judges in what we are doing at the moment, which is a compulsory training program for every single salaried judge about culture, what is appropriate and what isn't. But the other thing Sam did was to tell me the names of those judges where there were a number of reports. And once you've got the name where there are a number of reports, you can actually do something about it. And I'm pleased to say that we did do something about it, and there were 2 judges. They were spoken to. I won't say who they are or where they are or who spoke to them. And as I understand it from Sam, there are no longer reports being made about those 2 judges. So it does work. If you communicate the problem, and I'm not suggesting that it's your responsibility to do it. We've all got a responsibility. We can all do better, and I think one of the things that I've been saying in all the work that I've been doing on diversity, inclusion, discrimination, bullying, is everyone. I really think everyone can do better, and I include myself. I'm sure there are times where I say things that I shouldn't have said. But we can all do better, both in identifying behaviour that is good and not okay, and in calling it out if we see it, in whatever way we are able to do. And I'm not suggesting in the courtroom in the middle of the adversarial litigation is necessarily the way to do it, but action is taken if you do it.
So my next question, which I think you may have actually already just answered, Ingrid, was to what extent does the judiciary accept that there is a problem with bullying in court?
I mean, I think one of the problems is we don't know the scale or the incidence. The Lord Chief has talked about the number of salaried judges that there are and the thousands and thousands of cases that occur and are heard every day. And we don't have that sort of data. We do have the JCIO data about egregious cases, and very few cases are found against judges. But I do understand from Sam that around 5 to 10 reports are made each month to Talk to Spot. That gives us some idea. I mean, I think this scale is really actually quite small. On the other hand, as the Lord Chief said, judges are human beings. We are all members of a society in which these things happen, and there's no reason to think judges are immune. I don't think they're immune, the Lord Chief doesn't think they're immune, and we are proceeding, therefore, on the assumption that it does happen. And therefore, we are taking action to train and to communicate appropriate standards, what is expected, what is not, what good looks like, what is not okay. And that training, as I've said, is compulsory, and I'll come back to it if necessary.
Yeah, I mean, I think I'll move on a little bit, but we're going to talk about how things have improved, but I don't honestly think that's really very helpful. Obviously, they have improved, but they're not where they should be. I think we will agree. I mean, well, old people like me can definitely remember really grim bits of conduct which are rare now. But I did want to, sorry, I just did want to ask you, Sam, about, well, what's your response to that?
I think the point I wanted to make is when we ask questions of the whole profession, of those that have experienced or witnessed bullying, harassment or discrimination, the statistics are huge, and particularly in areas like crime, I think 62% of respondents had experienced or witnessed. And yet that doesn't translate into complaints and reports. There is a huge disconnect between those people who are willing to say in an anonymous report that they've experienced or witnessed bullying or harassment or discrimination, and those that feel able or confident in a system that's going to take steps to address it. And I think that's the biggest challenge that we all face, that, you know, and I don't want to underestimate how difficult it is to expose yourself in making a report, and the sort of the hurdles and the hoops that you rightly have to go through. If you're making a complaint about somebody, it has an impact on that individual that you're complaining about. So there are quite high thresholds of evidence that are required. But the problem is that creates this situation that we're in where we know there's a problem, but we can't do anything about it, and people can't complain, particularly I think around the low-level stuff. And I say low-level, the stuff that's just the wrong side of the line. It's very easy to make a complaint about something that is obviously such a severe incident that, you know, it's easy to deal with that. But we know that the cumulative effect of the low-level wrong side of the line is incredibly damaging to both the profession from a retention perspective, but also the judiciary from a reputation perspective. I'll stop there.
Mandy, can I say one slight line on that? And often, you say 62%, often before it even gets to that, often even before it gets to that place, particularly young advocates are put off from complaining by those people who they go to for advice and guidance. Often, and I've seen it being done, I've heard it being done, where they say, look, you know, don't worry about, that's just that judge, don't worry about it. It's not worth making a complaint. You've got your tenancy decision ahead of you, or you want to go for this, you know, so just leave it alone. And that, again, we have to do something to change that culture where actually going to people in the profession for support and guidance isn't met with, don't worry about it, it's just a one-off.
Don't rock the boat. You're doing really well.
Yeah, absolutely.
Don't rock the boat.
Absolutely. Yeah, and that is something. I mean, and that's not including the 60-odd%.
Yeah.
I think it's also just worth noting, the vast differences in different practice areas. Where you're looking at 3 times as many reports of an experience of bullying, discrimination, harassment in crime compared to commercial. There's something going on that we need to understand there as well.
Sam, I wanted to ask you this question because I think you're the only person in the room, certainly on the panel, that can deal with this because you're not a barrister and you've never been one. Why is it particularly difficult to try and deal with these things at the bar and the bench?
Because you argue back. I mean, the instant my experience of working with barristers, whom I love dearly, obviously, from working for the last 10 years for Bar Council, is, the first, you're trained to attack and to challenge and to rebut anything that is said to you, effectively.
Where's the evidence?
Exactly. Where's the evidence? Where's the evidence? And then to unpick the evidence and challenge the evidence. It's what you're all trained to do. And so you don't listen first and actually understand the intent of what somebody is sharing with you, that, what they just want to happen is for the behaviour to stop. There's not a kind of win-lose thing going on here. And I think that's what makes it really, really challenging with this profession. And judges are all lawyers. They've all come, many of them, most of them have come from the bar. So I think that's one of the problems.
Can I just ask Ingrid a question on this as well? Because hearing Sam say 62% of the complaints made are in the criminal courts, I mean, it's a fact, isn't it, that the criminal courts have been horribly underfunded for a very long time. They're horrible places to work in, by and large. I'm not trying to excuse any judge's behaviour, but that must surely come into the mix. The backlogs, the conditions, and whatever else is going on in their personal lives. And I just wonder, when complaints are made, and we understand that they're dealt with in a sort of behind-the-scenes kind of way at the moment, unless they're really, really serious, I just wonder whether if there was a more structured sort of, dare I use the word code, where people knew what the process was.
I'm not sure what process you're thinking about. I mean, you say they're dealt with in a behind-the-scenes sort of way, but every judge has a leadership judge. And if there is a problem, and the 2 judges that I referred to who were identified as serial offenders were spoken to by their leadership judge. It was a formal meeting with their leadership judge. There were discussions about the reports. There was follow-up. There was an expectation that the judges would respond and explain what they were going to do differently. And I've heard that in relation to other leadership judges who have had it brought to their attention that a judge is behaving inappropriately or that something's gone wrong in the courtroom that has come to the attention. So there is a route to dealing with those problems, starting with talking and looking for reflection by the judge.
One of the things I think that might be an issue and is the way people speak to each other. I mean, that is the root of a lot of what we're saying is happening. And is there any suggestion or is there any help for the judiciary in sort of how to communicate? Is there any training on that?
Not direct.
I don't mean that in a sort of simplistic way. What I mean is that a bit like having equality treatment, the bench book on equality. Well, that's trying to deal with those issues and highlight them to the judiciary. And I just wondered if there's any thought given
Well,
to that?
let me mention two things.
Yeah.
One is, and in a way it responds to Natasha's point, because I do think the criminal courts are under terrible pressure. They're not the only area of the judiciary, but they are. And we have organised, here's my note about it. We've organised a course called, or we've created, the Judicial College created a course called Access to Justice. And we made it compulsory for all resident Crown Court judges this year. It happened in January. The aim of the course was to provide judges with skills to deal appropriately and fairly with the diverse range of court users they encounter in the course of their working lives. And if I just tell you what the learning outcomes were that you would have a more in-depth knowledge of the Equal Treatment Bench Book and the issues which it deals with. You would be better able to recognise and understand diversity issues. You would understand the sorts of measures that can promote fairness to all court users, including unrepresented defendants. And there was a big, we had a session in the course of that course, which I went on to, that dealt with black defendants in the courtroom, black counsel in the courtroom, vulnerable defendants, young defendants, defendants with mental health issues. You will have knowledge of methods, and this may be the answer, by which you may adapt your working practices so that court users are not inadvertently treated unfairly and don't feel that they have been so treated. Understand how to balance the competing needs of individuals with the requirement that cases are conducted efficiently and expeditiously, and have information about resources available to assist you with the issues that you might meet. So that I think was a bespoke course. It was made mandatory for resident judges, and I thought it was a really excellent course. We've also got compulsory faculty induction now. Every judge who has started as a judge, as a salaried judge in the judiciary since 2019, must go on the faculty induction course, and that course includes an element called conduct and ethics. And during the course of conduct and ethics, we explore materials that the Law Society has provided with us, that the Bar Council has provided us with, that shows what they are doing to support members who complain about conduct perceived to be inappropriate. And that course therefore alerts judges to what is appropriate, what isn't, what is bullying, and also to the types of misconduct investigations conducted by the JCIO. I mean, there's other things. I know I've got a 2-minute limit,
you do.
But I'll shut up. But there's other things that I could cover.
You can.
I think this all sounds brilliant, but just going back to the starting point, because again, just drawing it back to this is a conversation about women who work within the courts, and again, the intersectional problem of women who are from particular protected characteristics. And these judges, and I make the point that they are a few judges, we're not talking about all of the judges, they make the decision, the choice, to treat certain groups of people differently. That's not something that a course is going to rectify. It's got to be a root and branch culture shift in how it is that we treat and perceive other court users. And so I think where we have complaints, where judges systematically treat women differently, treat women of colour differently, I think that needs to be met with a far more robust form of training, a far more robust form of accountability.
Well, that's unlawful behaviour. That has not come to me. No judge has been, that I am aware of, has been told you systematically treat women differently or you systematically treat black people differently. That I regard as utterly unlawful, and it would be a serious misconduct offence. But nothing of that sort has been communicated to me.
Can I make this observation, which is that once you become a full-time judge, unless you get to the Court of Appeal, you don't see how other people deal with their courtrooms. The only time that you do it is when you're on a judicial training course where you see how other people might attack a problem or approach something. Or worse.
Interesting that you use the word attack.
Exactly. I think that's a problem, actually. I think the fact that you get into, everyone gets into a rut. They get it, you know, we hear teachers doing the same thing. They teach the same course in the same way. That's why new teachers are often more exciting to listen to, because they're actually more engaged in what they're saying, and people haven't really thought over what they're doing. They're just in the swing of it. And so I wonder whether there's something to be said there. I don't know what the answer is.
Maybe the answer is appraisal. Maybe the answer is 360-degree appraisal. And that's something we are exploring. That's
very interesting. I'm going to now move on to the Court of Appeal.
My favourite topic.
Natasha's, not only Natasha's favourite topic, but her favourite court.
Not.
So, tell us, Natasha, about the Court of Appeal and the tone from the top.
Well, ever since I've been at the bar, the first time I went to the Court of Appeal with a very eminent silk who's still in practice, he was saying to me, how many notebooks should I put in my pants today? I said, why? He said, well, I'm going to get a kicking, obviously. And so there's this kind of expectation that when you go to the Court of Appeal, that every practitioner, it doesn't matter who you are, I would bet that nobody likes going there because of the amount of times they have to deal with what one might describe as classic bullying behaviour. Now, I know that's not necessarily going to find favour with everybody as a concept, but often advocates have to experience rudeness, humiliating behaviour. It's very upsetting for the families and the appellants who are there, who think they've got grounds and then think, well, why is my barrister being treated like that? And I just wonder, I know I'm not the only person to have experienced this. As I say, practically everybody I know has done. We can't all be bad. And I just wonder whether that sort of behaviour is condoned at such a high level, whether it has a trickle-down effect, particularly when circuit judges sit as wingers, as happens on occasion, and they look and they think, well, this is perfectly acceptable here, so therefore I can do this in my own court. I don't know the answer, but I do think that behaviour should be led from the top, and if bullying behaviour is going on up there, it needs to be addressed so that the effect trickles down all the way through.
Ingrid, do you want to say anything?
Well, I absolutely agree that bullying behaviour has to be squashed wherever it appears, and that we do need to lead from the top, and that it is critical that the senior judiciary is behaving appropriately. I mean, I hesitate to say this, but I think we've got to be very careful about some about context. When you go to the Court of Appeal, very often you're going there, the criminal division particularly, you're going there to renew your application for leave. You've already been turned down on the papers, your client has already been found guilty by a jury. And so it's a difficult argument that you're going to have to mount. Very often in the Court of Appeal, the judges will have formed a provisional view. If they didn't form a provisional view about the case that they're going to deal with, they could not survive, because we tend to have maybe, 6, 7, 8, I've even had 10 cases listed in the Court of Appeal Criminal Division. So you've read literally everything, you know what the argument is, and sometimes counsel come along and they are brilliant and they make their argument brilliantly, and the judges don't intervene, and they listen, and they deal with it. Sometimes counsel aren't brilliant, and sometimes counsel think that they are here to re-argue the mitigation that they advanced in the Crown Court, and that can cause irritation. I'm not saying that that is justified, but it can, and people express a view, and it's the way they express it, and they ought not to. But equally, there's a middle area where the judge will need to test the proposition that's being advanced, or the submission that is being put forward, or will need to bring an end to what is regarded as a misconceived argument. Now, I totally accept there are ways and ways of doing that, and there is no need to do it in a way that embarrasses or humiliates or undermines, and there's no place for that. But I do think there is a need to do that stuff in an appropriate way. And I mean, I'd love to have some concrete examples that I can then...
You've come to the right place.
Well, I know I have, because Natasha's we've discussed it. But you know, if there are behaviours that have crossed the line, I want to hear about them. And I know, because I've discussed it with the Vice President of the Court of Appeal Criminal Division, who was horrified when I told him that I understood that there were people who feared coming to the CACD, absolutely horrified, who would want to hear those examples or at least understand themes so that we can address them. So,
Ingrid, I think Natasha wants to come back.
Shut up, sorry.
Just one thing, because it's you know, you mentioned it's when people haven't got grounds and are renewing an application. It's not. It's often when they've actually got grounds, and they've got leaves, and off they go. And suddenly you get there and you're met with a barrage of behaviour that frankly wouldn't be acceptable anywhere else at all.
Well, obviously if it's bad behaviour, I totally accept that. But I mean, even when you've got leave, the fact is the client's been convicted by a jury. So there's an inbuilt hurdle that you're going to have to jump. You've got to either show that the conviction was is unsafe, or you've got to show that the sentence was wrong in principle or manifestly excessive. These are high hurdles to jump. That's really the point I was trying to make.
Sorry, I'm not going to let Natasha say
one thing, please. Because what you're saying about the pressures in the Court of Appeal, about having many cases listed at any one point, I understand that, but it also goes as well, doesn't it, with the pressures in the Crown Court, the listing pressures and so on, because a lot of what one might describe as bullying or rude behaviour that's totally unacceptable often emanates from pressures relating to time.
Yeah, it does.
And judges actually forgetting that the purpose is actually justice, and getting into this sort of trap that it's all about getting through the cases and getting through the list.
Yeah.
That's what causes so much of the problems.
Yeah, I think that is true.
We're moving on, because I can see that the Treasurer of Gray's Inn is very soon going to stop us entirely. So, what do you do if, how do you address the issue from the advocate's perspective? I think one of the things that we've talked about in the run-up to this is the confidence to address it. Laurie-Anne, do you want to add anything on that?
No, I mean, I think that, you know, I don't necessarily think when you don't address it, it means that you lack confidence. I think, you know, we have the confidence to go into court and represent other people to the best of our ability fearlessly. That's confidence. I don't think not addressing it means that you have a lack of confidence. It just means that what you have to go through in order to address and tackle the problem is so personally debilitating to you that actually you don't have the energy for it, and you're worried about the repercussions of it. And so actually there is a barrier to it, and it has nothing to do with confidence, but has everything to do with an inadequate system that allows for complaint to be made where complaint is necessary.
And moving now to Sam, what can we do? What are the systems in place to help us to report this?
Well, I think in the first place, I'd encourage people to be aware of Talk to Spot and to use Talk to Spot. I mean, it's really heartening to know that Ingrid has been able to act on the information that we have shared to date. So, you know, we need to know about it. We need to understand it. We need to understand how this behaviour is manifesting, the impact that it has. Who are the individuals that are responsible for the majority? We talked about the few. Who are those few? And I think being confident enough to use the systems and to recognise that only I see that information. It's completely anonymous. You remain in control of that information, and you will be guided through how we can use it in discussion. You will be protected. So I think what would be wonderful for me is if you can encourage others to use this reporting platform, because it will make a difference, it will have an impact. And also, the Bar Council is about to launch the 2023 Barristers' Working Lives, and we have added more detail on how bullying behaviour manifests across the bar. And I would urge you to take part in that survey and to encourage others in your chambers to take part in that survey, because having that data is what enables us to act on this behaviour.
And that's not necessarily instead of telling your head of chambers or telling a circuit leader or your roommate or your old pupil supervisor. You can do all of those things. And the thing about Talk to Spot is it is an app, isn't it? It's just something that you can access, and it doesn't have any human sort of interaction at all, except for you in the background.
Well, hovering. In the background, yes. I mean, you have the option with Talk to Spot to just make a record of an incident, even if you don't want to do anything with it, and it will just send you a PDF report of what's happened. So some people will find that helpful, and they may decide weeks later, months later, to actually take forward a report on that basis. And I think it's difficult language. Language means everything, but you know, in making a report to Bar Council, you're not taking formal action. You're just telling us about it, and we're going to guide you. So it's not that you can't automatically assume that submitting a report means the JCIO is going to know about it or the Bar Standards Board is going to know about it. It's very much just giving us the information and then us coming back to you and talking you through your options and supporting you.
So I have a suggestion for judicial training, and it's just my suggestion. I don't know what Ingrid will think about this, but because now every judge has to go to a course, don't they? Every year you have to go to the Judicial College. I think it's every year, or it certainly feels that way to me anyway. Why not incorporate a half-hour slot in every single judicial course on this issue? Because if you're a busy judge, you won't be thinking, oh gosh, I won't do serious fraud, how to do a serious fraud trial, or I could do judicial behaviour. No, I'll do the serious fraud trial. It's a serious point that I'm making. If you don't really have an option, it's just there as part of every single course. Yeah. And obviously it's not going to cover all the detail that you would cover in a whole course, but it just means you'll reach everybody much more quickly.
Yeah. Well, we're rolling out, as I said, the leadership culture training course. From April 2023, we'll roll it out for every single judge, every single salaried judge in courts and tribunals. And once we've done that, that is mandatory. They can't choose not to do it, and that will cover all of these issues. Once we've done that, we then have to work out how we continue that training and how we refresh that training. And I'm absolutely clear in my own mind that we've got to carry on doing it on a compulsory basis going on. It may be using your idea, adding half an hour on to other courses will be the way, but one way or another we've got to do it. So yes, I agree.
Well, I think we're going to have to stop. because the bar is calling. But I think there are some takeaways from this session, and one of them, I think, is from the Lord Chief's involvement and Ingrid on behalf of the judiciary, that we can be confident that this is a recognised issue that is being taken seriously, and that everybody wants to improve the behaviour of the judiciary in court. Secondly, that there is effective training being rolled out, and we hope that there'll be effective responses to that training. And thirdly, something I really do urge you to do, tell everybody about Talk to Spot, and please encourage everyone you know to fill in the Barristers Working Lives survey, because, as Sam says, what we will get from that is an undeniable evidence base of conduct which we simply shouldn't have to put up with at all. So those are, I think, the takeaways. And it just really falls to me to just say this. We are particularly grateful to the Lord Chief for taking time to come, to Gray's Inn, and to their treasurer, Lady Justice Nicola Davies, for giving us the ability and the authority to discuss this difficult issue openly and, more importantly, candidly and positively. And thank you all very much for attending, whether in the room or overseas online. Thank you all very much for helping us to have this event.
Amanda and I had agreed that she would do the vote of thanks. But I couldn't sit there and say nothing, because it's not only our thanks to our panel members for such a frank discussion. Thank you all very, very much indeed. But particularly to Amanda for moderating it so well and so effectively. A lot of work has gone on behind the scenes to get us to this evening, and to each one of you, our very grateful thanks. Many thanks.